Every day in the USA, people find themselves in court.
Have your name, please.
Carly Price.
All right, Ms. Price, we'll call your case next. This is the state of Michigan versus Carly Price, file 25-43882. We also have file 25-44052-FY. Man, the last case I called is a new case against you, so I'm going to arraign you on that one. And then we'll move to a resolution, or try to get a resolution in the older case that's against you as well. In the new case, I'll tell you what you're charged with, tell you what your rights are, and then we'll address the issue of bond. So the complaint in the new file against you reads as follows. It says that on or about July the 7th of 2025 in Bagley Township of Otsego County, you did commit the following 4 offenses. Count 1 is controlled substance delivery or manufacture of methamphetamine. It says that you did deliver the controlled substance methamphetamine contrary to the Michigan compiled laws. That is normally a felony offense of 20 years and or a $25,000 fine. However, the prosecutor has also filed what's called a subsequent offense notice, which doubles the penalty. It says that you were previously convicted of violating the Controlled Substance Act by delivery or manufacture of a Schedule 1, 2, or 3 drug on or about 2/5 of 20, and therefore there is a sentence enhancement to double the underlying felony penalty, and that penalty is now up to 40 years and or $50,000. Do you understand the name of count 1?
I do.
You understand the maximum penalty to count 1?
I do.
Count 2 is the exact same charge, and it says that you did commit the crime of controlled substance delivery or manufacture of methamphetamine, in that you did deliver the controlled substance methamphetamine contrary to the Michigan compiled laws. Again, it normally would be a felony of 20 years and or a $25,000 fine, but the same subsequent offense notice has been given, indicating the same offense, possession of methamphetamine on or about 1/14 of 2021, and therefore you are subject to an enhanced penalty of up to 40 years and or a $50,000 fine. Do you understand the name of count 2?
I do.
You understand the maximum penalty for count 2?
I do.
Count 3 says that you did is the name of it is computer network or communication to do a crime with a maximum over 1 year and a between 1 and 2 years. And it says that you did use the internet to communicate with a Mr. Fortier. I assume that that's a confidential informant, CI.
Yes.
All right. So you did communicate with a confidential informant for the purpose of committing a controlled substance delivery of methamphetamine contrary to Michigan compiled laws. That is a felony offense, has a maximum penalty of 2 years and or a $5,000 fine. Could also require reimbursement to the government for expenses incurred in violation of statute, and could be consecutive to the sentence imposed for a conviction on the underlying offense. Do you understand the name of count 3?
I do.
Do you understand the maximum penalty for count 3?
I do.
Count 4 is similar to count 3. It alleges computer or a network or communication to do a crime with a maximum penalty between 1 year and 2 years. And it says that you did use the internet to communicate with a confidential informant for the purpose of committing a controlled substance delivery of methamphetamine violation. Again, that's a 2-year felony offense with a maximum penalty of 2 years and or a $5,000 fine, reimbursement of the government for expenses, and could be consecutive to the underlying offense. Do you understand the name of count 4?
I do.
And do you understand the maximum penalty for count 4?
I do.
Well, it looks like I missed a count as well. There's a count 5. Before I get to that, all of these counts 1 through 4 are felony level offenses. Do you understand that?
I do.
because of that, even though there are drug enhancement charges on them, there's also been filed against you a habitual offender notice, which is another way to enhance the sentences against you. And it says the following, that you were previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about May the 9th of 2013, you were convicted of operating while intoxicated or impaired, third offense felony in the 46th Circuit Court for Otsego County in the state of Michigan. And then on or about February the 5th of 2020, you were convicted of the offense of controlled substance delivery or manufacture in the 46th Circuit Court for Otsego County in the state of Michigan. And then on or about January 14th of 2021, you were convicted of the offense of controlled substance possession of methamphetamine in the 46th Circuit Court for Otsego County in the state of Michigan. Therefore, if any of the underlying offenses have a penalty of 5 years or more, your penalty becomes up to and including life imprisonment. Do you understand that?
I do.
And if the underlying offenses have a penalty of less than 5 years, then the new maximum penalty is up to 15 years in prison. Do you understand that?
I do.
All right. There is one more charge that the prosecutor has made, and it is a misdemeanor charge. It's count 5, and the name of it is driving with license suspended. And it says that you did operate a motor vehicle on an area designated for the parking of motor vehicles, that is the Myers parking lot, while your operator's license was suspended or revoked. That is a misdemeanor offense. It has a maximum penalty of 93 days and or a $500 fine. It also involves vehicle immobilization. Do you understand the name of count 5?
I do.
You understand the maximum penalty for count 5?
I do.
All right. As to each of those charges, you have the following rights. You have the right to plead guilty, not guilty, or to stand mute. You have the right to have an attorney represent you, and you have the right to have a trial by a judge or by a jury. If you wanted to have a trial, you'd also have the right to see, hear, and question the witnesses against you. You'd have the right to present your own evidence and your own witnesses and get an order from the court requiring those witnesses to appear and testify. You could also testify, or you could remain silent. And if you remain silent, that could not be used against you. If you also at a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you have the right to automatically appeal any error at that trial. However, if in the future you enter a plea, you'd be limited to asking the court for permission to appeal. Excuse me. Do you understand all of the rights that I've just given you?
I do.
Do you have any questions about any of those rights?
I don't.
All right, Mr. Dick, I see that you are her attorney on the current case that's pending against her, 25-43882. I assume that you'll probably be appointed on this new case as well. Would that be a safe assumption?
Yes, I believe so, Your Honor.
All right, Mr. Brown, did you talk to Ms. Price about appointed counsel?
I did, Your Honor, and she did mention that Mr. Dick was her attorney. I sent that information to Mr. Gilo's office. She does qualify, and that is my assumption as well. So if it's okay with the court, I am going to defer to Mr. Dick, who I'm sure knows much more about this particular client.
All right. All right, Ms. Price, until you've had an opportunity to speak with Mr. Dick about this particular case, I'm simply going to enter a not guilty plea on your behalf in order to protect your rights. Because these are felony matters, I'm going to set a couple of court hearings in quick order so that your rights are protected as well. The first one is called a probable cause conference. That'll happen in the next 7 days, and Mr. Dick and the prosecutor will meet and try to resolve the case quickly. If they're not able to do that, within the next 21 days, we'll have a preliminary examination scheduled. That's a short hearing in district court. In front of me is the judge, where the prosecutor is required to show a small amount of evidence called probable cause that you've committed the crimes that you've been charged with. That is not a determination of guilt or innocence. It's simply a check to make sure that there's enough evidence for the case to proceed. Do you have any questions about either of those court proceedings?
I don't.
All right. What we're going to do next then is turn our attention to bond, and I'm going to ask each of the lawyers what they think bond should be set at, and then I'll give you an opportunity to tell me anything that you want me to know about bond as well. So Mr. Fortier, as to bond.
Judge, before I put the number out there that I'm going to ask the court to order for her bond, I do want to just make note of her prior criminal record. So in 2011, she was convicted of OWI twice, along with an MIP twice. In 2012, she got another MIP. In 2013, she picked up her third OWI, where she was charged with a felony. In 2013, she had a drunken disorderly and another MIP in 2020. I believe it was in 2021. She was convicted of, actually, no, that one. In 2020, she was convicted of delivery or manufacture of cocaine. In 21, she was convicted of possession of methamphetamine as a second or subsequent drug offender. Most of those occurring here in Otsego County. She's also got the pending case, which occurred after the fact, after the alleged offense dates in this one. So she's got the possession of methamphetamine, where she's charged as a habitual second offense notice, which should actually be a little higher, but then she's also got her the drug double. And in this offense, she's charged with 2 counts of delivery of methamphetamine as a second or subsequent drug offender, which puts her potential penalty at up to 40 years. These are not insignificant offenses. She has a history of delivering controlled substances. And in particular, in the case in front of the court right now, the first alleged buy or delivery of methamphetamine on July 7th was for a total of 14 grams of methamphetamine. However, she only actually delivered 4.4 grams, even though the full amount of the 14 grams was paid for. And the second buy in our county was on July 15th, where she delivered 7.2 grams of methamphetamine. These are not insignificant amounts of this very dangerous controlled substance. With her history, with the amounts that she's dealing, I also want to point out to the court that in the first buy on July 7th, she actually had her child in the car when that methamphetamine was delivered. So not only is she delivering dangerous drugs in our county, she's doing it in front of her children. I think an amount of $50,000 cash surety would be sufficient because she's facing significant prison time if she's convicted, and she's got a history, and there's a need to protect the community from her continued behavior. So in addition to that, I would ask that the court order no drugs, no alcohol, no controlled substances without a valid prescription, not to be in any bars, and to report via community corrections where she should be testing on random testing.
Thank you. Mr. Dick, as to bond.
Mr. Honor, while her criminal history is not insignificant, however, she is a mother. She does regularly work. We would ask that the court considers perhaps allowing her to be under some sort of house arrest with the ability to go to and from work, doctor's appointments, and court appointments with perhaps a GPS tether. As far as anything else goes, her employment definitely does not afford her the ability to post a bond for a $50,000 cash surety.
Ms. Price, you have the right to address me as well. If there's anything that you want me to be aware of, I would simply caution you not to make any statements about the underlying case or the underlying facts, because this is being recorded and I don't want it to be used against you later. But if there's anything that you'd like to tell me about your ability to appear, your ability to post bond, your employment, your finances, those kinds of things, I'd be happy to hear that now.
Yes, Your Honor. I just wanted to say that I do work full time. I do have my child full time, and I have always shown up to court dates in the past, and to just keep that in mind. That is all.
All right, thank you, ma'am. All right, I would note in the previous file that bond is set at, and that's file 43882 FY. Bond is set at $5,000 PR, and the allegations in that case are possession of amphetamine or methamphetamine with a drug double and habitual second, and then driving with license suspended. Much less serious, but she's been out on bond, much less serious than the current charges, but she's been out on bond, I believe, since July on that matter. This current file appears to be from the same time period, at least the alleged date that it occurred is 7/7, and I believe the date of the previous file 7/20. So this more, the current file that we're addressing today is actually precedes the previous one. And while I'm well aware of the felony record of Ms. Price, if she's been out for that amount of time on a lower bond, I don't know that she's going to be much more of a danger to the community or fail to appear now, simply because we've brought more serious charges. There is some concern I have that because of the much more serious charges, she may not appear and try to get away from the penalty for that. So I will enlarge the bond, but I'm not going to go up as high as the prosecution requests. Having said that, Ms. Price, if there's any deviation, that is failure to appear, any bond violations, anything, whatever, I'm going to take that as that I was wrong and you need to stay in jail until your case can be resolved. Do you understand what I'm saying to you?
Yes, Your Honor.
So it is absolutely paramount that you keep your nose clean, that you do what you're supposed to do, you be where you're supposed to be, you keep in contact with your attorney, and you cut ties with whoever or whatever has caused you or may have caused you in the past to come in contact with the police. You can't afford to be in jail if you've got a child at home, and I'm not going to have you out there continuing to do this. Not going to say that you do, but can't have this kind of stuff on the streets, period. So I'm going to set bond at $5,000, cash surety or 10%. That means you got to post $500. You'll also have to appear at any court date scheduled by the court. You must abide by any judgment of the court. You may not leave the state of Michigan without permission of the court. May not commit any crime while on release. You must immediately notify the court in writing of any change of address or telephone number. You may not use alcohol or illegal controlled substances. Must participate in a substance abuse testing or monitoring program through community corrections, and that would be random testing. You may not enter a bar or place where alcohol is sold by the glass. You must report to community corrections, and the jail will give you that number to call upon your release. They're the people that monitor the people who are on bond on felony cases for the court. So you'll need to know when to call in, when not to call in, how to get a hold of them, and how they get a hold of you. I am giving you somewhat of a break, Ms. Price. Don't screw this up.
Thank you, Your Honor.
All right. Then, Mr. Dick, as to file number 25-43882-FY, that matter was adjourned to today's date. See if we had a resolution. Where are we at with this case?
Your Honor, in light of the new file being opened, we are going to ask for this to be continued just to allow us to try to work out some sort of a global resolution to these cases.
Next time we have some time available.
So her new case will be back on 10:30. 1:45, so we can schedule that at the same time.
Yes. All right, Mr. Dick, we're going to put these together on October 30th at 1:45.
Very
We'll
good. Thank
have
you, Your
both
Honor.
cases together at that point. This current case is getting really, really old, so I need a resolution of that. So let's make sure that you've talked to Mr. Fortier. Mr. Fortier, if you put a note on your file or whatever needs to be done there so that the two of you talk and we do everything in our power to reach a resolution. Obviously, Mr. Dick has to get the permission of his client, and if that doesn't work, it doesn't work. But I'm going to want to set preliminary examination dates or something to get the cases moving, simply because the other one, the current one that I'm looking at now, 43882, is back from July, and it's been a long and winding road and needs to be taken care of. So let's get a deal. If we can't get a deal, let's get a prelim date set. All right. Thank you. That's all for today.